Yes, Mr. Allen, I think we're going on to diversion of project now, aren't we?
Indeed we are. Yes. So the conclusion and reasoning as to diversion are contained within paragraph 176 of the judgment, and that's at page 119 of the core bundle. Where the judge says this, that there could, I agree, be no objection to SES just selling the lines. What, however, is contrary to SHA, the SHA, is SES and the respondents entering into a turnkey arrangement with Infinity Max, using CGI as the vehicle for the turnkey agreement. That was, in my judgment, and this is the relevant finding, a breach of the non-competition and business promotion clauses in the SHA. It caused prejudice to the Dodsons, and that prejudice was unfair. So, the first point to note as regards diversion of the project, this stage of the judgment, is that it's concerned only with breaches of contract, namely breach of the non-competition clause and breach, which is clause 7, and breach of the business promotion clause, clause 2.3. No reliance, it goes without saying, on or reference to any equitable constraints, and nor, in passing, a finding of breach of the duty of good faith that we looked at before. Yeah. The non-competition and business promotion breaches can be considered relatively briefly. As regards the directors and SES, if applicable, the judge accepted that the project was dead as far as IAEP was concerned, and we need just to look at his findings as regards that. Paras 174, in particular 174. So the petitioners say that the project was diverted to IAEP CGI. Mr. Reed's answer to this in his closing submission is the affairs of the company were conducted in accordance with the terms upon which the parties agreed, etc. And he sets out various matters there and comes to a conclusion in 28.3. It is clear from the evidence that by the end of October 2013 onward, and then there's a square bracket inserted by the judge, and he set out various ways in the project as at that date was effectively dead, and I'll come back to that. I think the judge was just wanting to do that slightly shorthand. And he goes on, and then at para 175, he says this: I agree with these points as far as they relate to the period up to the 2nd of January 2014. Now, if we pause there, that means is that the judge has agreed that it was clear from the evidence that by the end of October 2013 onwards, the project as at that date was effectively dead. And the section is headed, of course, diverting the project. So it's clear what he means by the project, which is a combination of the sale of the lines and the turnkey. And just to amplify somewhat the finding that the judge has made, if we actually look back to paragraph 101, page 100, I think we can see what those matters were that the judge sort of left out, as it were, by putting them in square brackets. You'll see that paragraph 101, again, on this occasion, cites Mr. Reed's skeleton opening, but if you look at 60.3, you can see that he says by the end of October 2013, and he sets out a series of matters, lines not sold, etc. And they're plainly in my submission the matters that the judge was just sort of chopped out when he recorded the closing. And so the judge found that the project was effectively dead by October 2013, and that, of course, is obviously right. IAEP was hopelessly insolvent at that point. Had no assets and no means to pursue the project, absent an injection of funds by SES, And that's even if you don't, let's assume for the purpose of that analysis that some element of the technical library was owned by the company, contrary to our submissions today. It had no way, the company had no way of realising any value from that unless the project went ahead. It didn't have the right to or the ability to exercise the option, and it owed a significant amount of money to SES. And that's why the judge concluded that come October 2013, the project was effectively dead. As a matter of contract, therefore, and I understand the position has different characteristics, or capable of having different characteristics when we look at the breach of fiduciary duty allegation or finding, but for present purposes, we say as a matter of contract, there can be no question of competing with the company because the company had no business with which to compete after October 2013.
Well, is that right? Can we just go back for a moment to paragraph 22 of the judgment? The judge sets out clause 2, which defines the business. And clause 2.1 talks about the business of the company, which is the design, sale and implementation of turnkey automotive engineering products. That's then called the business.
Yes.
And 2.2, the first project will involve the acquisition of the lines.
Yes.
So when the judge finds the project was dead, he's talking about clause 2.2, isn't he? Not clause 2.1. So
He is, yes, I would accept that.
Right.
Yes.
So clause 2.3, each party shall use its reasonable endeavours to promote and develop a business to the best advantage of the company. SES could have sold the lines and engaged IAEP to provide the turnkey services, could it not? Could have.
It wasn't SES that was engaging anybody to provide the turnkey services, my lord. It was ultimately IML, who were the purchasers of the lines. They were the ones going to do the business in China.
Right.
One question, and I think it is a question that your question gives rise to, is to what extent does SES have any obligation to bring about a situation in which the company could actually proceed with the project or any business connected to the project?
Well, SES is a party, isn't it, to the shareholders agreement?
It is a party to the shareholder agreement.
And each party is to use its reasonable endeavours to promote the business.
Correct.
So it might be said, might it not, that SES and the individual shareholders owed a contractual obligation to try, at any rate, to persuade the ultimate buyer of the lines to engage the company to provide the turnkey services. And as far as one can tell from the judge's findings, nobody did anything of the sort.
But the point was that on the judge's own findings, from October 2013, the project was dead.
The project was, yes.
Yes.
But the project was the acquisition of the lines plus the provision of the turnkey services, not simply the turnkey services, which were covered by clause 2.1.
But the turnkey services, my lord, would themselves have entailed a very significant investment. What you had to do was ship the lines, which you didn't have, over to China, as it turned out, and service the contract and so on. So what, in my submission, the judge is saying is, in effect, the company is insolvent. That's because it owed a significant amount of money to SES, had no means of executing the option, and therefore, in effect, it was over. It wasn't just over for any specific activity within the project or connected to the project. It was simply a company that had no life at that point.
And therefore, clause 2.3 didn't bite, or clause 2.3 required something to be done, but not very much?
Well, first it only required reasonable endeavours.
Yeah.
Now, in my submission, reasonable endeavours could on no view be extended to providing finance to bring about a situation that couldn't otherwise occur. But I don't think even have to go so far as showing that, because if we look at the shareholder agreement, I hope I get right clause first time round, and behind tab 14, there is a provision in, I think 6.2.
Sorry,
yes,
which clause?
clause 6.2 at page 56.
2. Yes, no obligation to provide further finance.
Now, I would say that a reasonable endeavours clause could never, even without that, extend to an obligation to commit funds that you're not otherwise obliged to commit. But with that in place, in any event, in my submission, that puts that to bed. What we don't have, as far as breach of the reasonable endeavours clause in any event from the judge, is findings that the company, or rather, sorry, the appellants could have done certain things, and those things would have led to a consequence. And in my submission, we don't have that, not because of omission, but because it's inherent in the judgment that no such steps could have been taken. And therefore, when we look at what competition means, we have to look at the reality of that word. Objectively, what does it really mean? And how can you be competing with a company that is essentially insolvent and incapable of carrying forward any business? So that's the competition side of it. So far as the business promotion clause is concerned, you have my submissions that even looked at in isolation, that clause couldn't import a requirement to invest further money on the part of SES. Or perhaps more specifically, impose an obligation on Mr. Shield to cause SES to introduce any further money, or indeed any of the other parties. If you like, that was the whole basis of the contractual structure between them. Here's the option: you either acquire the lines or you don't. In the meanwhile, SES in the meanwhile has lent a significant amount of money. The position that had been, excuse me, the position that had been arrived at by October 2013 was that money was just not going to come back. The project was dead. I quite take the point, my lord, about the business being defined as these various other potential future activities. But one also, when looking at whether there's competition, in my submission, you have to look at the reality of the situation.
Well, I mean, just going back to clause 2 for the moment.
Yes.
There are potentially at least 2 points here. One is, was there a breach of the obligation? In other words, did the parties, including SES, use any endeavours to get IAEP signed up to provide the turnkey services? If they used no endeavours at all, which seems to be what the judge found, then one can see there might well have been a breach. Did that breach cause unfair prejudice? Well, if no amount of endeavours would have got IAEP into that position, then I can see the argument of saying, well, even if it had been a breach, the goal was unattainable, and therefore there's no unfair prejudice.
Well, I would endorse that entirely. That situation is something I am coming to, and those are points that I will make, and I accept them gratefully at this stage. But the problem on the judgment is that the judge hasn't made any specific findings of what reasonable endeavours were not undertaken. And certainly if one starts to speculate that it might be putting in finance where finance was not otherwise available, or forgiving liabilities that were already out there, that in my submission would go way beyond what the reasonable endeavours clause could possibly envisage, and moreover in any case runs straight into clause 6.2.
I don't recall that the appellants have ever had a case that they did anything.
Well, there were,
could have amounted to reasonable endeavours. I don't want to be unfair to you, Mr. Matlin, but I'm not aware that there's anything.
well, there were certainly various discussions taking place about various possible outcomes. But my point, my lord, is that there is no finding of the endeavours that were not taken, as it were, undertaken, the things that were not done. And the only things in my submission, once you accept the judge's starting point finding as to the state of the company in October 2013, then the only way in my submission the company could move forward to do anything would be with finance. And if the finance isn't forthcoming, then nothing can happen. And if there's no obligation to provide the finance, then in my submission there can be no breach of the reasonable endeavours clause. But, and well, this is what I'll come to in a moment, even if there were, it would be, so sorry, apologise. It would be very much a breach that did not cause prejudice to the company. I mean, and I also should say that if the judge is going to find that reasonable endeavours were not taken, in my submission, it is incumbent on the judge to identify the endeavours that should have been undertaken or could have been undertaken and contrast what happened with that situation. And I should point out as well, just in passing on this, it's something we address in our skeleton argument at paragraphs 46 and 53 to 56. There are critical factual findings in the very short paragraph dealing with these issues that are plainly wrong. So, for example, just going back to paragraph 175. Mr. Shield would have a larger shareholding in CGI than in IAEP. There's no evidence, and it is not the case, that Mr. Shield had any shareholding in CGI.
I think that's now common ground. I think it's acknowledged that was a mistake by the judge.
Yes, but what's said is that the judge must have been referring to something else. But what I'm submitting to is that this is indicative of the fact-finding and analysis in respect of this breach. It's not good enough to look at what the judge actually found and say, well, he's obviously made a mistake, he must have meant this. It is damaging, if you like, to the reasoning process. And also, contrary to para 176, SES and the respondents didn't enter into a turnkey arrangement with IAM. The turnkey arrangement was as between CGI and IML. But that does bring us then to the loss/prejudice point to which you referred. We submit there's no possible loss and hence no possible prejudice that could flow from the alleged breaches if, as the judge found, the company could not have taken advantage of the opportunity itself. In that context, it's important to note this, that there's no finding by the judge that IM would have engaged the company or that the company could and would have won the contract but for CGI. On the contrary, there's a finding in effect that it couldn't because of the state of affairs by October 2013. So if you can't find, you don't make a finding that but for what went on, IAEP would have been the contracting party, then in my submission there can't possibly be any loss. Now, if there's no loss in that sense, in my submission there can't be any prejudice to the company arising out of the breaches, even if there were such breaches. Now, Mr. Kanguri addresses the diversion allegations in paragraphs 77 to 85 of his skeleton argument. But in fact, in those paragraphs, it's my submission.
Which paragraphs?
77 to 85.
Yeah.
But my submission is, as regards those paragraphs, that he actually offers no contractual analysis in support of the judge's conclusion. In particular, there's no argument as to why the judge was right to find a breach of the non-compete and business promotion clauses. And in my submission, that's because there is no argument that could support those conclusions. Mr. Kangaroo does suggest, paragraph 84, that the company was the natural party to deliver the turnkey project. And he refers to some draft documentation. In my submission, that completely misses the point, that the company could not, without more, engage in the turnkey project. And the judge hasn't found that it could, because it was hopelessly insolvent. And that brings us back to the introduction of funds point. Unless and until such funding was forthcoming, the company couldn't undertake the project. So this suggestion that the company was somehow the natural party to this to the turnkey project takes the respondents nowhere. But in any case, it doesn't even feel right as an observation, because as your lordship indicated earlier, the project is clearly defined in the SHA, in the shareholder agreement, as the acquisition and provision of the turnkey services. They go together, at least in the first instance. And so it's far from clear that IAEP would have been, in any circumstance, the natural party. But of course, it could not be the natural party or any party in the situation that it actually found itself in October 2013. So we said that if that analysis is correct, whether or not there's a breach, there's no prejudice suffered and no unfair prejudice, and therefore no basis for the petition to succeed on the question of what is called by the judge diversion of the project. That then takes us, unless I can help any further with that, to breach of.
Do you feel right so far the petition should have been dismissed?
Yes.
We're now proceeding on the assumption that you're wrong in one or more of the grounds of appeal. Are we? We're going on to data valuation and so forth.
No, I'm on breach of fiduciary duty.
Oh, breach of fiduciary duty.
Because they're addressed separately by the judge.
Yeah.
So first
Contract
diversion, and then next breach of fiduciary duty.
Yes.
Forgive me, I don't want to slow you down, Mr.
No,
Mayor, but just very briefly. Can I make sure what the premise of the submission you've just finished was? Because the question is, do you have to be right about the technical library for the submission you've just made about no loss, or is that submission made irrespective of your position on the technical library?
That's a very fair question, if I may say. If there is a finding that the technical library had value and was diverted away from the company, then there would be a loss involved in that, though, irrespective of this competing point. And I should have picked up on that, yes. No, I accept that. But, and this is a very important but, you of course have to define the prejudice that is being relied on in order then to frame the an effective remedy process. So it's not good enough, obviously, just to leap to oh well, there was some value in the technical library, therefore there's unfair prejudice, let's just go away and value the company without clear findings that guide that process. And that's, just to pick up on it very quickly, that's one of the real concerns about the technical library in the first place, where we say, first, there's no proper evidence at all of ownership, but even if you pick out some evidence of ownership, there's a real concern about how far that can go and to what it extends, principally because the judge focuses on the shop floor library when he makes his findings about breach, as we saw earlier on, and that is, I think, why your ladyship had in mind that he was disregarding the archive because that was already with BMW, but he plainly was disregarding the archive copy in those findings. And we know that as regards the shop floor, we essentially just have the Mr. Collins evidence. And just to be very clear on that, the only evidence that the judge relied on there appears on its face to be concerned only with line 1. If it's any more than that, it's possibly lines 1 to 3, but there's no clear indication of that. But it certainly isn't line 6. It can't be, as a matter of timing. And it's a real concern that one could sort of simply slip to a position of saying, well, there must be some value in the technical library. We can't say exactly, you know, what went where and so on. And then the position becomes impossible to deal with as a matter of making the remedy, if there has to be one, fit the prejudice, because we don't know exactly what the prejudice is. But that all, of course, is without prejudice to my primary contention. Just bear with me 1 second. Yeah, so breach of fiduciary duty. Here, the analysis and conclusions are all set out in paras 177 and 178 of the judgment. And it's our position that the judge's analysis and conclusions are again flawed for reasons that I'll go into now. The actions relied on were transferring the technical library. That's para 176 of the judgment, and that of course goes to my Lord's question about the position as regards the technical library. That's found to be a breach of fiduciary duty, and permitting CGI to carry on the turnkey project. Those are the actions. If we look at 177 and 178. And note again the point in 177, no meeting of directors was held to ratify the transfer of the shop floor technical library. The main actors, then we go on, Mr. Shield and Mr. Cottrell decided what should happen. Mr. Cataneo, etc. went along with it. All of them continued to work for CGI in the rollout of the project and acquiesced in the diverting of the project to CGI. Well, that acquiescence that's being referred to there obviously goes back to the diversion that's being contemplated higher up, and as regards the diversion of the project, you already have my submissions as regards that. But we say that I'm not going to go back into the ins and outs of the technical library. I think I've answered, my Lord, in relation to that. But we say this, that in order to make any assessment of whether there was prejudice to the company, it was also essential for the judge to view the outcome as a whole, which he clearly failed to do. Now, focusing just for a minute on the technical library point as regards breach of fiduciary duty, because one can readily see that if it's established the company has an asset and the directors divert that asset away, then that is prima facie a breach of fiduciary duty. But we're concerned with two things here. We're concerned with the breach of fiduciary duty as a step along the way, and then we're concerned with a broader concept of prejudice, and in particular unfair prejudice. Now, the actual facts were these, that as we say in paragraph 79.2 of our skeleton argument, the company was released from IM's $5 million claim as part of the transactions. We can see that, if necessary, in paragraph 1 of Schedule 7 of the asset sale agreement, and I'll give you the reference there is supplemental bundle 28238, but I don't think there's any dispute that the document was intended to release the company, amongst others, from IM's very significant claim. I'm sure the court has seen reference to the claim suggested by
It was
IAM.
about 5 million, wasn't it?
About $5 million, yes, in their letter of claim for fraudulent misrepresentation
Yeah.
as to ownership of the
And
lines,
I think
etc.
somewhere there's a valuation of the technical library at 4.9 million. Seem to remember.
Yes, but there's no, there was a document containing that,
Yeah.
but there's no,
No formal valuation, no. But
absolutely.
so the claim and the assumed value of the technical library were roughly equivalent.
Well, I would not accept that, my lord, because I know it'll be our client's case that the technical library had very little value at all. That wasn't an accepted valuation, and the valuation was obviously not before the court. I know the document went in.
It was before the court.
The question of valuation was not before the court.
No, as the judge said.
As the judge rightly said. So, in my submission, you have to look at it in the round. You had directors who achieved one thing, which is the elimination of the claim against the company. The company's position at the end of this was that it no longer had the claim against it. It did not participate in the turnkey project, but it never could have participated in the turnkey project anyway. Reasonable endeavours and so on notwithstanding. So we say that the judge simply failed to engage with that exercise. It was crucial to do so in order to consider the question of unfair prejudice, but instead he sort of dealt with it really in very summary form. In fact, I think as far as breach of fiduciary duty is concerned, he didn't even arrive at the conclusion about unfair prejudice, but if he did anyway, there was no reasoning of that. And it's fair to say, my lords, it's fair to say that the petitioners, the respondents to this appeal, are very dismissive at this point. Mr. Kanguri says in paragraph 115 of his skeleton argument that it's an afterthought and that the judge accepted that IM was merely using the threat of litigation as a bargaining tool. And in support of that, he points to paragraph 51 of the judgment. Now, we say it's worth having a look at paragraph 51. That's not really a fair reading of what paragraph 51 says. That's at page 88 of the judgment. And it says, notwithstanding Infinity Max having caused the letter before action to be sent, all the witnesses who were concerned in negotiation with Rosenblatt and Infinity Max agreed that Infinity Max was still interested in finalising the deal. Although on its face, he notes, this is surprising. They all considered, he's just recording the responses now of the individuals, that the letter before action was merely a hard-nosed, albeit a very hard-nosed, negotiating strategy being advanced by Mr. Sampson. Indeed, this belief was borne out by the letter of 21st November, discussed below, from Rosenblatt seeking to foster a more open dialogue. So, all that is, be that as it may, as it were, that's the approach the judge took to the letter, but he didn't, in my submission, find that IM was merely using that as a bargaining tool such that there was no threat to the company implicit in that and no benefit to the company in being released from that threat. In order to do that, in my submission, he should probably have weighed up the position at the relevant time when the prejudice is said to have been caused and determine whether there was in fact prejudice when you looked at the entirety of the situation. On a very simplistic analysis, the position is this. You have an insolvent company facing a $5 million claim at stage A with no possibility of engaging profitably in any business because it doesn't have the funds. At stage B, after the conduct in question, you have an insolvent company with no possibility of engaging in any business that is not facing a potential $5 million claim. That, if anything, is plainly a benefit on that analysis, but what it certainly isn't in my submission, or what it certainly doesn't point to, is any unfair prejudice. And this is perhaps a theme that runs throughout this area of the judgment is that, yes, of course, it's right that breaches of contract and breaches of fiduciary duty can constitute, and often will constitute, unfair prejudice for the purposes of the section. But you still have to follow that through. You can't just stop at the level of saying, well, there is a breach, and then conclude, as the judge does in one line, therefore there was prejudice and therefore it's unfair. It requires a consideration of all the circumstances to see whether that's right or it's not. And in a situation where the breaches in question don't actually damage the company, it's my submission that you have to be very alert to determine whether there is in fact relevant prejudice or not, and the judge didn't do that.
We're not concerned, are we, with prejudice to the company? We're concerned with prejudice to the petitioners.
Sorry. Yes, you're quite right. I'm sorry. Prejudice to the petitioners, to the shareholders. But obviously it comes via the impact on the company, yeah. But I accept that correction entirely. Yes, you're absolutely right. So that's pausing really on the question of the direct impact, if any, of the technical library. Because what we're submitting there is that even if there were a breach, even if there's some value to this technical library, you needed to look at the matter in the round. If you'd looked at the matter in the round, there wouldn't have been any prejudice. And that analysis, the no prejudice, obviously applies equally to the pursuit of the turnkey, or more simply, in fact, to the pursuit of the turnkey. But before you get to that, you have to ask the question whether there is in fact a breach of fiduciary duty. We say the same competition point arises as to what you're competing with. There may be this distinction that where you're concerned with fiduciary duty, the question of impossibility of pursuing the opportunity is not a bar to the breach of fiduciary duty. And I accept that. It's different from the contractual position. But the question of whether there is competition still has to be determined. That doesn't get washed away by the fiduciary duty question. Equally, the way my learned friend puts it, the judge didn't put it this way, but he puts it in the sort of language of maturing business opportunity. You have to decide, as a matter of fact, that this was in fact a maturing business opportunity before there can be any possibility that there is a liability as fiduciaries on the part of the directors for the diversion of that opportunity. And we say, as a matter of analysis of the facts, in essence, those facts that are in the judgment, not correcting them or overturning them, there was no such competition, there was no such maturing business opportunity. Goes back to the point in a way that your Lordship made, that the opportunity in front of the company at this point in time was the sale of the assets, purchase and then sale of the assets, plus the turnkey.
Well, leave section 994 out of it. Let's just think in terms of fiduciary duty. Yeah. And let's assume there is an insolvent company, a business opportunity arises, the insolvent company can't take it up. And the directors decide they'll take it to themselves and they make a lot of money out of it. The company would be entitled to an account of the profits, would it not?
On those facts, yes.
Now, is that different once you bring in 994 and you require prejudice? Is it a prejudice that the shareholders don't get to participate in a profit which should have come to the company?
I understand the question entirely, and that's something I'm just going to come to in a second.
Right.
But before doing so, I just wanted to finish on the question whether there's a breach in the first place, yeah, before we get to that. Because whilst I do accept the point that impossibility via, in your Lordship's example, insolvency, isn't itself an answer, going back all the way to Keach and Sanford and all those sorts of things, that doesn't address the point of whether there was in fact competition. That's a different thing. Here we're saying this was not competing because it wasn't the company's project, and it equally wasn't a maturing business opportunity of the company. There is in addition the point of impossibility because of impecuniosity, which in my submission certainly goes to questions of loss, but also goes, I think, to questions of competition in the contractual environment. But I quite take the point that the circumstances are somewhat different when one's looking at breach of fiduciary duty, and it wouldn't be sufficient simply to turn around and say, well, no problem, no breach, no liability to account because a company couldn't do it, so I'm perfectly free to walk off and do it myself. No, I entirely accept that's not the case. But just before we move on to the question of interrelationship between remedies for breach of fiduciary duty and prejudice, our starting point is there is no competition in the first place and no diversion of a maturing business opportunity for the reasons that I've said. Then we get to the two-stage question, if you like, of the consequence of breach of fiduciary duty and then the consequence of that on prejudice in an unfair prejudice situation. So there are broadly two potential consequences of breach of fiduciary duty in these circumstances. One is that you're liable to pay equitable compensation to the company. That is rather similar in my submission to the contractual analysis. There has to be a loss. There is no loss in this case. The other is, and the one that would be invoked in a situation such as this, were one to get that far, is a liability to account, as your lordship indicates. Now, we say that a liability to account for profits can't itself be prejudice to the company, because the company never had that opportunity. What equity is doing when it imposes that liability to account it's in a sense a mechanism to control the fiduciary, if you like, so that the fiduciary, to keep the fiduciary to his duty in the strictest sense possible. And the authorities have always recognised the fact that there will be many circumstances in which that liability to account can effectively bring a windfall to the principal, who never could have taken advantage of that in the first place. That, the authorities are absolutely clear, doesn't stop the liability to account happening. So the fiduciary has to account, but what it does do is indicate that this is a particular area of the law. And if you're looking at real prejudice as opposed to notional prejudice, the fact that the company couldn't have participated in the activity does mean there's no prejudice in my submission, albeit there is a potential liability to account on the part of the fiduciary. And we just pause there for a moment.
Why couldn't the shareholder say, I've lost the opportunity to participate in the profit which you, delinquent director, should have accounted to the company, for which you, a delinquent director, should have accounted to the company? That would have been millions of pounds and I would have had my share of it.
If the director had accounted, rather than because the company would have participated in that in the first place.
Well, no, not necessarily, because we know that the delinquent director has a duty to account for the profit he makes, even if the company couldn't have participated, because Section 175 tells us so.
And it's
so if the director fails to account, when in fact he should, why can't another shareholder say, I have been prejudiced because I'm no longer participating in the profit for which you, delinquent director, should have accounted?
Well, I think my answer to that is this, my lord, that there has not been a failure to account, if you like, unless and until a liability to account accrues, and it's found that there is such a liability. As I say, in my submission, the liability to account comes from a very particular area of the law, which has developed over a considerable period of time for very particular purposes, and should not be taken as extending to constituting prejudice to the company in circumstances where the company couldn't itself have benefited. But I quite understand your lordship's point. But what I would say is this, that the judge has not analysed the the case in this way at all. So he's not saying, well, the prejudice to the company is that there is a liability to account and that has not been satisfied. If he had been doing that, then certain consequences would have flowed from that. So, for example, when we had the consequentials hearing, you will have seen that the date as for valuation was fixed as at April 2015. Well, at that point, there can't have been a liability to account. Leaving aside just for a moment the question of technical liability, there could possibly on some, but certainly not as regards the diversion of the project or anything, because there were no profits at that point in time. Nobody had made any. So if you're looking at prejudice, you've got to look at the reality of the situation. So a party at that stage obliged to account for profits. There were no profits. And the profits of the directors, qua defaulting directors, if that's where you get to with the analysis, are arguably very different from the profit the company might itself have made had it engaged in the exercise. And because the judge has not analysed through the nature, if any, of the prejudice, we got to a point in the consequentials hearing where certainly Mr. Kangaroo was making submissions. It's all very, very straightforward. All you have to do is take the date back to 2015, assume the project would have gone ahead, and there you are.
Yeah.
But that just can't be right if, as we follow through the analysis now, and we get to the point that even if the judge is right about breach, the only way you could even possibly, and I still submit to your lordship there are arguments about that, but that you could only possibly get to prejudice via an unsatisfied liability to account, then you have to be very careful about what that liability to account is. So what are you actually doing? What is the prejudice so that at the stage of valuation, there can be a proper valuation. There's a basis for that valuation. What would that basis be? I ask somewhat rhetorically, given the judge's findings at present.
Yes.
And it might be just worth picking up, because this goes to, I think, the diversion of project and this fiduciary duty point, that in paragraph 101 of my learned friend's skeleton argument, yes, my learned friend refers to the fact that we rely on Corowin, a paragraph from Corowin, as authority, that it's difficult for a petitioner to establish relevant prejudice where the breach does not give rise to adverse financial consequences. And that's a theme underlying both of these areas of investigation. And he says the full passage to Ray Corowin at 631 needs to be considered, and I think that's actually fair. We ought to look at that just quickly. It's in the authorities bundle at, I'll just find it. It's at tab 12, tab 11, sorry. And we hope this wasn't inappropriate, but after discussion with a learned friend, we cut down Ray Corowin to the introduction and this paragraph, because it is a very large judgment. It really was only this paragraph, I think. Apologies, I know that's not the right way to do things generally. So if we look at, begins really under the heading prejudice at paragraph 630. And this is what's said: where the acts complained of have no adverse financial consequence, it may be more difficult to establish relevant prejudice. This may particularly be the case where the acts or omissions of breaches of duty owed to the company rather than to the shareholders individually. And of course we've got both here. If it is said that the directors or some of them have been in breach of duty to the company, but no loss to the company has resulted, the company has not had a claim against those directors. It may therefore be difficult for a shareholder to show, nevertheless, as a member, he has suffered prejudice. And then he goes on, the judge goes on to refer to ROC nominees and sets out a passage which we should take a quick look at in light of the account of profits point. As to the judge's finding of breach of fiduciary duty on the part of respondent directors, plain that, as the judge found, respondent directors were in a position of hopeless conflict. Further, they would undoubtedly have been well advised to obtain an independent valuation. However, no harm was in fact done and no damage or prejudice was caused, nor is there any question of the respondent directors being personally accountable in any way. And so you can see that there is a carve out there. It's not developed, and the court has my submissions in relation to that. But it's only fair to point out that that is a carve out, if you like, a qualification, if you like, that the judge makes when he's talking about the question of prejudice for unfair prejudice purposes in circumstances where there's no damage to the company.
Yes.
Look, if could just give me a moment. Yes, so just finally in wrapping that up, it's important to note in my submission that all of this analysis is actually based on a consideration of the judge's own findings, save as regards technical library. And we've had to make certain submissions about that. But otherwise, what we're trying to do is tease through the impact of what the judge has actually found to see whether he's arrived at conclusions that are sustainable and make proper findings as to prejudice, unfair prejudice, and a basis on which a remedy could possibly be granted. And if I could just ask for a moment. I am reminded, and this is a fair point, that the case was not put by the petitioners on the basis that the unfair prejudice caused was a liability to account. And that's obviously why the judge hasn't dealt with it. And in those circumstances, in my submission, one should deal squarely with the way that the judge has dealt with it and arrive at the conclusions that I've already invited. Well, that takes me to minority discount in the event that the court is against me as regards liability, in inverted commas, for unfair prejudice.
Yeah. And I think you need to approach this on two bases, as Mr. Kanguri does.
Yes.
One, if it is a quasi-partnership, and the other if it's not.
Absolutely, yes. No, I thought we had done that in our skeleton argument, albeit relatively briefly on the alternative.
I think you accept, don't you, that if it was a quasi-partnership, then full value without minority discount is at least the starting point.
It is at least the starting point. Yes, I do accept that. I don't say it's the end point, but I do accept that it's the starting point. So we say the starting point on the analysis of whether there should be a minority discount in circumstances where there is not a quasi-partnership is that a company should be valued for what it is. And we explain that, it's a fairly obvious submission in paragraphs 94 to 99 of our skeleton argument. Clearly a shareholder doesn't have any beneficial interest in the assets of the company. He simply owns an asset which has a number of characteristics. Those characteristics contribute to an assessment of its value. One of the characteristics when it's a minority shareholding is that the holder does not have control and there may be difficulty in selling his shares. We say though that's part and parcel of the asset that is owned. And we say that in any valuation, starting point is that has to be taken into account. That's the default position, and without more, if it were otherwise, a minority shareholder selling his shares without a discount would receive a windfall, because that's simply not something he could have achieved in the real world. A discounted value, on the other hand, puts the shareholder in the position he would have been had he remained a shareholder. The value of the shares is all that the shareholder ever owned. That's what he has. He has these shares. They have that characteristic. Therefore, there is no starting point prejudice to that shareholder in only receiving a discounted price for his shares, because that's all he ever owned. Now, the court will be aware there's been something of a split on the authorities as regards the impact of a finding that there is not a quasi-partnership, and its impact on the question of minority discounts rather gone down 2 lines. But in my submission, the starting point is, as we say in paragraph 97 of the skeleton argument. Just to pick that up. And as the court will see, one begins with the well-known authorities, well-known in this area at least, of Strahan and Wilcox and Irvine and Irvine. And perhaps we can just pick those authorities up in turn. So the Strahan authority is at tab 7. And if we can, without going into sort of too much of the background, just pick it up at paragraph 17 under the heading, was there a quasi-partnership relationship?
Sorry, paragraph?
17, sorry. And the court will see there, the burden of the dispute between the parties on this appeal is as to the basis of valuation. Shares are generally ordered to be purchased on the basis of their valuation on a non-discounted basis, where the party against whom the order is made has acted in breach of the obligations of good faith applicable to the parties' relationship by analogy with partnership law. That is to say, where a quasi-partnership relationship has been found. And Justice Sargent goes on to say, it is difficult to conceive of circumstances under which a non-discounted basis of valuation would be appropriate when there was unfair prejudice for the purpose of 1985 Act, but such a relationship did not exist. So we say that's the starting point, and we say that's right.
I mean, if the judge had found a breach of a contractual obligation to act in good faith, that might be a relevant circumstance, wouldn't it?
No, my lord, we say it wouldn't, because the contractual duty of good faith, as we saw on the relevant authorities, is not tantamount to a duty of good faith in a partnership circumstance. So you're simply not in the territory of a quasi-partnership and an arrangement analogous to a partnership. And we'll see in a moment why the authorities say that that distinction exists and should exist. So if we then turn to tab 8, we pick up the Irvine and Irvine case. This is a first instance decision of Mr. Justice Blackburn in 2006. And if we start at, just pick it up quickly at paragraph 1, tells us what's going on. So the judge had handed down judgment, found that unfair prejudice had been established, expressed the view in valuing the shares that should not be a minority discount, that has now heard argument and concluded that that position is still correct. Note in passing, paragraph 2, that the minority had 49.96 and only just under half of the shares in the company in that particular case. And then if we go over to paragraph 4, the court will see that the judge records that most, if not all, of the authorities in which the question has been raised, or had at that time, of course, been raised, whether the shares in a company which is the subject of Section 459 petition should be valued pro rata or on a discounted basis have been cases where the company is or alleged to be a quasi-partnership. And certainly Ms Roberts was unable to draw the judge's attention to any in which non-discounted base evaluation would apply to a minority holding in a company not a quasi-partnership. Now if we go down to paragraph 6, we see that the judge there refers to the Strahan and Wilcox decision of the Court of Appeal, albeit recognising, well, I recognise at least that Justice Arden was speaking obiter at that point. That's only fair to point out. And he cites the relevant passage. And then he actually explains the reason for the distinction. That's at paragraph 7. He says the reason for the treatment and evaluation of shares in the buyout order in a quasi-partnership case was offered by Lord Millett in CVC Opportunity, a case in 2002 of the Privy Council. And it's worth just focusing on this for a moment. The rationale for denying a discount to reflect the fact the holding in question is a minority lies in the analogy between a quasi-partnership company and a true partnership. On the dissolution of a partnership, the ordinary course is for the court to direct a sale of the partnership business as a going concern, with liberty for any of the former partners who wish to do so to bid. But the court has power to ascertain the value of a former partner's interests without a sale if it can be done by valuation. The valuation is not based on a notional sale of the outgoing partner's share to the continuing partners, who being the only possible purchasers would offer relatively little. It's based on a notional sale of the business as a whole to an outside purchaser. And of course the point there is that a partner has a beneficial interest in the assets of the partnership, and a departing partner in the normal circumstance would give rise to a dissolution of the partnership where the assets are distributed at their full value. As the passage there points out, there are circumstances under which that doesn't need to happen because the court orders a valuation, but it's a valuation, of course, premised on the consequence of a dissolution, which would be the normal circumstance in a partnership. The consequence of the dissolution, which would be the normal consequence of a partner departing from a partnership. So that is the rationale as given there by the judge. And it's worth just going on a little bit. Paragraph 8, he says, is there any reason in the present case for concluding that although it's a minority holding, and although CHO is not a quasi-partnership, fairness requires the petitioner's shares to be valued on a non-discounted basis? And it refers back again to late Justice Arden. And it's worthwhile just looking at the arguments advanced in support of the submission that such circumstances did exist in that case, because it said that although Malcolm's death, since Malcolm's death, it hadn't been a quasi-partnership, the company remained nevertheless a family company. The articles, just looking down, the articles contained restrictions on the transfers of shares. There's no open market for their disposal. Treating the shareholding of the parties as a combined holding, the difference between that holding and Ian's is only 1%, and so on. And leading to the conclusion, if this was not a case where a pro rata basis evaluation should apply, it would be difficult to think that any such would ever arise. And then there were counter submissions in paragraph 10.
The main point was it was a matter of principle, and Mr. Justice Blackburn seems to agree with that at paragraph 11.
Yes, and my reason for sort of referring to those reasons and the judge's dismissal of them is that these are the typical reasons that always come up in these sorts of circumstances. Terribly unfair. Why am I getting why am I not getting full value? And the recourse is always had to the fact that, of course, the valuation has to be fair. But it has to be fair, in my submission, within the prescribed principles. And if you start from the position that a minority shareholding naturally and inevitably takes with it a discount, you then say, yes, but the law has carved out a particular circumstance under which that's not true. That's very different, just approaching it in that way. And then, of course, the question is, are you in that circumstance? Approaching it that way is very different from the way I think the authorities have developed subsequently, which is to say, well, if there's to be no discount in the case of a quasi-partnership situation, why should there be no discount in other circumstances? And what that ignores is that the correct starting point isn't any presumption at all. The correct starting point is a factual observation that this is a characteristic of the shares that has to be valued. The presumption then comes when you look at a particular area of English law as it's developed for the reasons set out there. And in my submission, if one looks at it that way round, the answer to this question becomes a lot clearer.
Mr. Mellon, if the judge was right, and I know you say he wasn't, and we don't need to go back over it.
No.
The judge was right that there was no means of forcibly buying out, of taking out your stake. If that was true, and as I said, I repeat it, you don't need to go back over the submissions you made, I get them. That would make it, in the context of the valuing of the shares, more like a partnership. Doesn't more like a partnership. It doesn't import all the partnership obligations, but if you can't sell your stake, then it is more like a partnership in that respect, in the respect which Lord Millett identifies as being the reason for valuing it that way.
I take issue with that, if I may, my lord, because in my submission, the inability to exit a company when you buy shares in a small private company, that goes with the territory. You are a minority shareholder.
The consequence of the shareholding agreement, not the fact that we all know you can't necessarily sell those shares in the real world because no one will buy them from you. But if the contractual terms which you signed up to mean you can't do it, why is that not the same sort of thing as a partnership in the context of how you're valuing the minority share?
Well, you can do it in the context of a partnership. It's just that it has certain consequences. So a partner can leave. It's not that there's no ability to leave, it's just that the consequence of leaving would be a dissolution of the partnership. Whether a partner can or cannot leave and under what circumstances that partner can and cannot leave, but obviously that would depend on the partnership agreement. But that, in my submission, doesn't flow from the rights and obligations that you have as a partner. What those rights and obligations do is give rise to this unusual situation that if you are a leaver, because I would submit anyway, because you are a beneficial owner of the assets, there has to be a dissolution of the partnership.
But there's another point here, I think. You have taken us to the company's articles,
Yes.
which enable a shareholder to sell their shares.
Yes.
First of all, there's a right of preemption given to the existing shareholders. Then the board of directors can sell them, and if they don't want to, then the shareholder can sell. And in any of those cases, as I understand it, the shares have to be sold at a price not less than, quote, fair value, unquote, which is defined by the articles.
Yes.
And I think you told us that fair value involves valuing the shares without discount for minority.
But what it actually says, and I think in fairness it comes to that, it says without regard to the number of shares that are being sold,
Right.
or the percentage of the total shareholding that they constitute.
Yes.
Just to be accurate on what it
All
actually
right,
says.
so let's call it undiscounted for shorthand.
Yeah.
If the only way that the shareholder can get out of the company is by selling for not less than the undiscounted value of the shares, why should he have to accept less on a buyout order under section 994?
This rather goes back to the question you asked me earlier, my lord, I think, which is that it doesn't matter what the articles say in one sense. When the sale is to an outside party, you're only ever going to get what that outside party is prepared to pay. The fact that the articles say, well, you can set your price at a fair value is neither here nor there. as to what that person will actually pay. So you are always a shareholder with a minority interest and nothing more. In other words, the articles can't wish a price that doesn't exist. They can only govern the dealings as between the shareholders. Now, I know, of course, that the buyout order, in fact, is an order that that shareholders purchase, but it's a completely different situation because it's a forced purchase, and the premise is a fair value, which is assuming a willing buyer and a willing seller. And a willing buyer and a willing of a minority shareholding would not pay, or at least depending a little bit on the circumstances, but generally would not pay a non-discounted price for the shares. And that's the premise of the valuation. So whilst I follow your Lordship's point, in my submission, that those provisions of the articles don't actually impact on the question of what is a fair value for these purposes.
Right.
And I'm not sure that I've fully answered my Lord's point. What I was really trying to get over was that, first, of course, I don't accept the premise, and I don't even actually, in the context of our discussion now, fully understand the premise of a non-enforceable exit, or whatever the right expression was. But I think that my submission would be, even if in some sense that was so, it doesn't somehow lift you up and drop you into the territory of partnership. Not least because actually that wouldn't apply to a partner. They're just different animals, I think is the, putting it rather crudely, is the way I'd try to answer that. And it's worth noting, you know, that is, as the court pointed out, a distinction of principle. It's not saying, oh, well, it would be jolly unfair if there's been wrongdoing and therefore you've got to accept a minority discount. That's terribly unfair, therefore that's not going to happen. That's not the principled way to approach these matters. Just let me check that. Anyway, we know, of course, that there are now a few first instance decisions that have declined to follow the approach set out in Strahan and followed in Irvine and Irvine. Others have followed it, in fairness, but the principal ones that didn't, on which the respondents rely, were, or at least included, Ray Sunrise Holdings, that was a judgment of his own Judge Pearl at the time, in 2009, and Blue Index, a decision of Mr. Hollington KC, sitting as a deputy in 2014. It's convenient to take the effect in my submission of these authorities by reference to Mr. Hollington's own textbooks, because what he does is he summarises the effect of them and then sets out why he thinks they're right, because obviously he was the judge in the Blue Index case, and so he does think it's right, and he was quoting in the Blue Index case the Sunrise case, so it all kind of comes together in one place. And that is to be found behind tab 21. Sorry, just a little bit tidy up here.
Of 854 and following.
Yes. Yes, so we see the heading quasi-partnership, that's at 853, and then other relationships, the norm. And what the judge there does is he sort of reviews the authorities and let me just, if we just if I could perhaps just invite the court to just skim down that, if I may, just to get the flavour of what it is that the judge is saying, rather than dwell on it for too long, and then we get to the conclusions. So you can see how the argument develops, and it leads to the conclusion in paragraph 856, starting from the point that if the company is not a quasi-partnership, there must be exceptional circumstances. And he said that's based on analogies with other contexts where the courts have to value minority shareholdings. First, the law of partnership, correct. Secondly, a number of statutory provisions, which we're not concerned with here. And then the learned author says this, that whilst by analogy with the law of partnership, the presumption is that there should be no discount for minority shareholding in a quasi-partnership where the court makes an order for the purchase of shareholding under the unfair prejudice, it is not obvious that there should be a presumption the other way if the company is not a quasi-partnership. I would take issue right there with that approach and that logic. It's not a question of there being a presumption the other way, as I said a moment earlier. It's that without more, That's what the value of a minority shareholding is. It's not a presumption. It's simply a fact of valuation. The presumption is then that in certain limited circumstances, namely where there's a quasi-partnership, that reality, if you like, can be displaced. But if there is not a quasi-partnership, you're simply defaulting back to the reality. You're not relying on any presumption. So that the author's concern that he can't see why there should be a presumption is misplaced, because with respect to him, he's misunderstood the logic of the position. And we can deal with his bullet points, and I deal with them because they really encapsulate, if you like, the debate around these two lines of authorities. And so the first one really repeats his point in just above. Whether the relationship is one of quasi-partnership or not does not seem to be an adequate basis for distinguishing cases. A quasi-partner may be entitled to relief under the unfair prejudice remedy in circumstances where the court would not have made a winding up order. So the availability of relief by way of winding up is not the determining factor. In my submission, that doesn't address the principle behind the distinguishing of quasi-partnership cases that we saw in the Irvine and Irvine case, relying in turn on the CVC case in the Privy Council. So that's the first bullet point. In the second bullet point, in circumstances where a majority shareholder has by his unfairness forced the minority out, which is hardly an exceptional case, it is wrong in principle that the majority shareholder should profit by the application of a discount, since the majority will usually benefit from the marriage of the minority shareholding. There's a couple of things to say about that. The first is, as regards the marriage question, which I'll come back to in a moment, in my submission as a matter of principle, that should be irrelevant, because what one's looking at is the value of the shareholding to a willing buyer. The impact upon the actual purchaser in this case is, in my submission, irrelevant. But I can come back to the...
Yes and no. I mean, even if you're looking at a purely open market valuation, if there is a special purchaser with a particular interest in acquiring the shareholding, you have regard to that special purchaser.
Yes, but the valuation here is not put on the basis of the particular special purchaser, namely the other shareholders. It's a market price.
Well, that's the point. In a market price, if in the market there is a special purchaser who will offer more than anybody else.
But that has to be a willing buyer.
Yes, so you might
premise.
You would ask if Messrs Dodson sold their shares, would the remaining shareholders wish to buy them? And if so, at what price?
Well, that may be so, and there may be some marriage value, and actually it's a point I will come to, because it arises in the Ray Edwardian case. There are some observations about that, and I do want to come to that. But my starting point, submission, my lord, is this, that it isn't actually relevant, because the special characteristics have to be of a willing buyer. The premise here is a forced sale to that person. And it has to be borne in mind in my submission that a majority shareholder already suffers a potential disadvantage in buying out a minority in circumstances where he could otherwise, and often does, simply sit back and let the minority stay there. That, of course, is the consequence of his prejudicial conduct, but it is already a disadvantage without then leaping to the conclusion, as it were, that in order to make things fair, you need to have a discounted value to the shareholding. Put differently, going back slightly to the point I made before, all the minority ever had was a shareholding subject to those characteristics. The purpose of the remedy is to wash away, if you like, the prejudice, and that is washed away if the minority shareholder gets what he always had. Comes back in essence to that. Third bullet point is to do with, and this is at the top of 333, to do with statutory squeeze out. I'm not sure there's any relevance of that to things we're concerned with, and so I have no submissions to make about that. The fourth point made by Mr. Hollington is that the courts don't in any case treat a minority shareholding for what it is. He says this: in the real world, the value of a minority shareholding in an unquoted private company is usually much less than its pro rata value. This is because there's usually no market for the shares. The majority shareholder control the company without needing their cooperation. Put the matter another way, minority shareholder would often, although not always, have little or no value but for the statutory remedies on the unfair, prejudice or just and equitable grounds. Instead, and by which he means instead of valuing them at almost zero, the courts readily adopt artificial discounts provided by valuers, ranging from about 25% to 40%. But I find that a somewhat surprising submission, because obviously the court seeks to ascertain fair value, having regard to expert evidence. The expert evidence says what the impact of the non-marketability and the lack of control is, and that evidence is heard by the court, and the court makes a decision. I find it surprising that Mr. Hollington would say actually what the court's doing is making a wholly artificial decision. That's not really what it's worth at all. That's just what we'll say it's worth. And that seems to be the sort of premise of the bullet point, really. Well, to be honest, everybody, we don't really treat this by any reflection of reality anyway, so we can chuck reality out of the window completely. That's, in my submission, with the greatest respect to Mr. Hollington, not a principled approach, and not one this court should adopt. The final bullet point is, in passing as it were, is minority shareholder may have subscribed for shares at their full pro rata value. Well, that's as may be, but they've still subscribed for shares, having the characteristics they have. Whatever level they subscribed for them at, they took on, the shareholder at that moment in time, took on an asset that was effectively subject to that discount and paid whatever they paid for it. Of course, in this case, it was a startup operation, so the subscription was fairly nominal, so it wouldn't apply anyway. So, in summary, we say that the court should follow the very persuasive authority of Stratton, as reinforced by Irvine and Irvine in the context of CVC, the Privy Council case, and adopt the approach that unless there is a quasi-partnership, there should not be a minority discount, or to use the terminology of the authority, it would only be an exceptional case. I want to refer just quickly, I seem to have lost the reference to the where Mr. Joffe deals with this issue, because he takes the reverse approach, and I think the passage should now be in your, when I say reverse, the reverse approach to Mr. Hollington. In other words, he essentially puts it the way that I've put it to your lordships, to the court. If you look at minority shareholders behind divider 22,
It's paragraph 779.
that's right. I'll just catch. That's where the section begins. I wonder if we could go forward to 790. Under the heading, the company is not a quasi-partnership, and the shareholder has acquired the shares on an undiscounted basis. And you'll see there that the author sets the question Notwithstanding the shares represent a minority interest, where the company is a quasi-partnership, the shareholder may have acquired his shares on an undiscounted basis. Less frequently, majority shareholder may acquire his interests on an undiscounted basis. In these or similar cases, should a minority discount be applied? And the author reviews the authorities, again going through from 791 to 796, which I don't think we need to dwell on unduly. It's the same collection of authorities, Sunrise, Blue Index. And he concludes then at 797 as follows: the English authorities therefore fall into two groups, which we've already identified. Index, and he also mentions admins, which hold that the general rule in a company which is a non-quasi-partnership is a minority discount should not be applied, save in particular circumstances, such as acquisition at discount. And two, cases such as Strahan and Irvine, and he also mentions CF Booth Limited, which proceed on the basis the general rule is as we have stated. It points out that the point needs to await determination by an appellate court. It may well be that as a matter of principle, the latter group of cases, namely the Strahan and Irvine case, is to be preferred. There is some apparent force in the view that the reinterpretation in Blue Index and Bird Precision Bellows is not entirely justified. He points out that sections of Northjay's judgment in the latter case are stated in fairly bald terms, to the effect he's only setting out a rule in the case of a quasi-partnership company, and some of the support called in aid of reinterpretation in Ray Blue Index is equally susceptible. And he comes to this conclusion in 798. In the case of a quasi-partnership, the principal basis for not applying a discount is that explained by Lord Millett in CVC Opportunity Equity Partners Limited. No such basis exists where there is no quasi-partnership, a point not addressed in Blue Index and Ray admins, and that is the point that I've emphasised to the court. The absence of that basis would appear simply to suggest there should be no general presumption either way in the case of a non-quasi-partnership, but the rule should be one which requires the petitioner to justify why there should be an undiscounted valuation. So it's not a question of presumptions, it's a question of reality, and now you've got to find a reason. And he then talks about Singapore authorities and moves down to 7101. It appears that the English courts are heading in a similar direction. In Esther and Singh, and that is the Ray Edwardian case that we referred to earlier, after acknowledging but not completely resolving the different approaches, Fancourt J confirmed there is no presumption in favour of pro rata valuation in the case of a company that is not a quasi-partnership. He had adopted a line of reasoning similar to that expressed above, that there were, in the case of the relevant company, which was not a quasi-partnership, no considerations binding the other shareholders to treat the shares as having a pro rata value. And the author then does make one point which goes rather back to the marriage value issue that we discussed a moment ago. And this derives from the Ray Edwardian case, or at least it's also addressed in the Ray Edwardian case. And he says this at 7102. The choice is not necessarily between an undiscounted and a fully discounted valuation. In Ray Macro, Arden J split the control premium between the petitioner and the respondent. The question was also considered in Richardson Lundy, where it was held that the court had power to make to order the purchase of the petitioner's shares not merely on a pro rata or a fully discounted basis, but also to order a valuation applying an intermediate discount. In my submission, for that to be properly principled approach, it would require expert evidence as to the nature of the and extent of the discount. For the reasons I said before, in my submission, it's not the correct approach, but it is certainly gives more recognition to the reality of the situation than a non-discounted basis. So whilst I don't urge that approach upon the court, nonetheless, it is available if the court is not satisfied entirely that fully discounted valuation should be ordered. Can I, sorry to do this, but just before moving on from that, can I just go back to a paragraph in Mr. Joffe's text? Should have picked it up as I went through. It's paragraph 799.
Yes.
It's this point. Mr. Joffe says that, put another way, although perhaps not expressly articulated in such terms in the authorities, there is a principal distinction in the case of a quasi-partnership company or company with equitable restraints superimposed on the party's rights. What the petitioner is selling or parting with is his shares with the benefit of those equitable entitlements or restraints. Inevitably, that is worth more than a minority shareholding without those protections. Conversely, it's not necessarily unfair for a minority shareholder in a non-quasi-partnership company to be bought out at a discount. If a discount is generally not applied, then a minority shareholder may receive a windfall, absent circumstances under which it might genuinely be considered the petitioner has been ousted from a position of imminent sale or beneficial winding up. So that is, if you like, a sort of expansion of the principled rationale for applying a discount where there's a not applying a discount where there is a quasi-partnership, and vice versa.
Yes.
And that brings us then to the, those are my submissions on the position if there is no quasi-partnership, as we said there is not. Alternatively, we address the position if there is not, or rather if there is a quasi-partnership, at paragraph 100 of our skeleton argument. And make the point that even if we don't succeed in relation to the appeal on quasi-partnership, we submit the judge was still wrong and failed to weigh all relevant factors in the balance. And here, of course, we accept, as I indicated earlier, that the starting point is where there's a quasi-partnership, that the normal but not invariable order is that no minority discount should be applied. But we say it's important not simply to apply a label without consideration of the substance. The real issue is whether applying a discount to reflect a commercial market value is fair in all the circumstances. It is generally considered unfair where a quasi-partnership is found to exist because, and this is quoted from the case of Dinglis and Dinglis, it's obviously unfair to apply a commercial market analysis to someone who is being forced against their will to exit what is in substance a partnership. But for the reasons we set out, we have already, or I've already canvassed, that's not the position in this case. First, because this isn't an exclusion case, it's based on different considerations. And also because there's no question in any case, whatever finding there is as to whether there's a minority, whether there's a quasi-partnership or not, it remains the case that the judge hasn't identified and has not relied on any breaches of any equitable considerations. So that it doesn't, even if for other reasons that the court finds that there was in fact a quasi-partnership, the rationale still does not apply because you're not in a situation where there's been a breach of these equitable constraints on the conduct, where something tantamount to a winding up should occur. So we say that even in that circumstance, what you're really looking at here, in essence, is breaches of contract, and as between the shareholders, and breaches of duty of good faith, only as between the shareholders and the company. And that puts the situation, we say, out of the norm of the typical quasi-partnership situation, such that it remains the case that a discount is for the minority should be applied.
Right.
And that then takes us, my lord, to the question of valuation date. which I can take largely by reference to as skeleton argument of paragraphs 83 to 93. The central point here, without going through those paragraphs at the moment, is that the business is a risky venture that starts out in around 2012, 2013. The judge has found that there's no way that the company could, in any event, have proceeded with the project after October 2013. As a matter of fact, we know, and the judge, I think, records at a certain point in his judgment, but there are public documents showing it, the project ran into all sorts of difficulties.
Well, the judge recorded some evidence at paragraph 93 and declined to make findings.
Yes. But then, at the consequentials hearing, material was put before him that indicated quite clearly as findings of the judges. We can look at that if need be, as to the fact that the project had already run into difficulties in 2016.
Your point is that he should either have made some findings about what happened to the project or allowed that to be raised on the consequentials hearing, but to decline to make findings and then to shut out any evidence of what actually happened, it was just wrong.
Well, yes, and it's not just a question of evidence, because of course it goes to the valuation date.
Exactly.
So, yeah, yes, exactly. So if the valuation date were later, inevitably you take into account what actually happened. The impact of what actually happened on the valuation date earlier is I'm not sort of conceding anything on that. There are circumstances where you can look to subsequent events, but that would be relatively limited.
But why is the court exercising a very broad discretion under section, whatever it is, 994 or whatever the relief section is? Why is it required, if it fixes a valuation date, to adhere to all the principles that would normally apply on a valuation? Why can't it say, for instance, value as at 2015, but take into account what happened afterwards?
Well, these are the sorts of...
It wouldn't be a classic valuation.
No. I argued it, it has to be said in front of the judge, on the basis that the only way of getting properly at the counterfactual, if you like, being able to analyse the counterfactual by reference to the actual, was by doing a later valuation date. But of course any form of valuation that permitted consideration of that, rather than the wholly unfair situation of a party being taken out, if you like, of his shares in a company.
No, I fully see that. I fully see that. I mean,
and of course,
you know, we thought we were going to make a big profit on this. In fact, it turned out to be a disaster. So it was as it turned out, it was a worthless opportunity.
yes, and that was very much the point I was trying to get over to the judge, and of course it also links to the question of minority discount. I mean, how more unfair could something possibly be than somebody being bought out on at an undiscounted basis from what, on the premise, must be a going concern, because you're looking back to April 2015 on assumptions that I don't even understand, but in order to give the huge value that the petitioner would attribute to it, there must be making certain assumptions about what's going on. So you're in that business, in counterfactually, in 2015, with the possibility no more of this business arising and so on and so forth, and you're able to sell your shares on a non-discounted basis, assuming all these rather good things happen, when the world knows they never did.
Yeah, well, I think Mr. Hollington refers somewhere in his book to the Bulfer principle, Matt Norton's famous saying that why should he, with the light before him, why should he grope in the dark?
Absolutely, I know. These are the sorts of points I tried to make to the judge, but I was making them, to be absolutely fair, in the context of saying the consequence of all this
Yeah, well,
accumulated unfairly.
that's one way of doing it.
It's a later valuation date. But in a sense, the valuation date is a bit notional because as long as it doesn't shut out those considerations, because nothing happened to the company itself
Yeah.
between 2015 and later. The critical thing is, what do you build into that valuation, and what are you entitled to take account of in considering that valuation? Those are two variables. The first, obviously, is a consequence of what findings are ultimately made as regards the existence or otherwise of unfair prejudice, because you can only give a remedy that reflects that, and so you can only build something back into the company that the company should have had, in effect. And that's where you run into, in my submission at least, problems with the account of profits issue and what that means, how that plays out. That's the first thing. And then the second thing, as your Lordship points out, is, well, what do you actually take account of in that valuation? Because you cannot get away from standing back from this situation and going, the petitioner is coming to the court seeking many millions of pounds because people treated him badly, his case, in relation to a company that never would have made any money, never could have made any money, or not, at least not the sort of money that he's talking about. So that's a step back point, but because we're dealing with issues of fairness, it seems it's a more appropriate point to make than it might be in other circumstances. So the job of the court is, of course, to arrive at a fair remedy, and that's fair feeds into valuation date, minority discount, and so on.
Speaking for myself as a man, I can understand how if the valuation date is later, then the point of setting a date is to say what factors do you take into account to decide what its value is on that date. It's a bit like if I had the right to compel you to buy my house 2 years ago, the fact that it had fallen in value after that isn't a reason why I shouldn't be entitled to force you to pay what you would have paid for it 2 years ago, because it's about the risk, who's bearing the risk of what happens afterwards. So I can understand why, from your point of view, it's right to say, to push the date forward into the future to take that into account. I get that. I'm not sure I understand how it would work to say, well, I'm going to value it at an earlier date, but take into account what happened after that. At the moment, I mean, you put it forward, but I don't understand how that would work.
Well, it wasn't the way I advanced it. I think
I'm sorry,
I think it was a hair I set up.
but it was one that I was more than happy to merrily chase after, in fairness. I think my point really was in agreeing with your Lordship was that as long as there is a mechanism for a properly fair valuation taking into account all relevant factors, if there were a way of doing that with an earlier valuation, well then so be it. Our primary position remains that the valuation date should be later for all the reasons that I had said to the judge and have repeated in brief to the court today. That seems in many ways the cleaner way of doing it. But as I say, our critical point is that it cannot be a fair outcome as currently structured. It's a complete win-win. I didn't take any of the risk of the project. The project failed, but nonetheless, you've got to buy me out on this premise, and that in my submission just can't be right and cannot be a proper exercise of the court's powers under section 994(6). I wonder if I could just.
Yeah, there's one curiosity. If you look at the judge's order, which is the order under appeal, as far as I can see, he hasn't actually ordered the appellants to buy the respondent's shares.
Oh.
Unless I've missed it.
No.
There's some declarations. This is page 123. Some declarations about quasi-partnership, unfair prejudice, unfair breach of duty. Then there's a refusal of permission to appeal. Then no further step should be taken to trial of issues of quantum valuation. Then there are some directions about the quantum trial. petition is to set out the methodology, date of valuation, no minority discount, application permission refused, further direction. There's no actual order for buy. To buy.
I confess I hadn't picked that up, my lord.
I suspect nobody wants them, Mr.
No, quite. I might just sit down right now. Yes, so.
I mean, I assume that's just an error. And that everybody knew that what the judge was actually doing, even though he didn't say so, was to order your clients. Well, at least I'm not sure that it is necessarily your clients. It's at least some of your clients, which is because I think Mr. Rock is not one of them.
No relief was sought against Mr. Rock. That was expressly stated.
So there ought to have been some sort of order saying who was supposed to be buying these shares.
I can't, of course, suggest that it wasn't in the judge's mind and intention.
Well, I think it must have been.
Such an
So
order should be
it was
made,
the
'cause that's
assumption
what we were
that that's
talking
what he
about.
was going to do, but it never actually found its way into the order.
No, I don't quite know how to correct that, but it'll need some sort of correcting. But of course, it may not, depending on the outcome of this appeal.
Yeah.
But
Right.
where one is left, of course, quite apart from the fairness of the outcome, which I hope I've addressed the court on, is a complete unworkability apart from anything else. Now, it may be said, well, that can all get resolved during the valuation phase if we get to that. But for reasons I hope that I've explained, I'm not sure that's right on the findings that are made in the judgment.
Yeah.
I wonder if the court give me just one. No, thank you very much. Those are my submissions.
Thank you very much, Mr. Ballard. Yes, Mr. Kanguri.
My lady. May I just approach my submissions on this basis? First of all, I'd like to go into the background of the case and the factual circumstances behind what occurred during the course of this litigation, and then address the grounds of appeal. I'll try to do them in the same order that Mr. Malins considered them. Now, if I may take you to my skeleton, please. I make reference there to the fact that the petition was presented on the 2nd of September 2020, and the three main grounds that were relied upon, and two of which succeeded before the judge. Now, as far as the company is concerned, it was incorporated on the 26th of September 2012, but what you don't have there, but you would have picked up from the judgment, is that the shareholders of the company were not only the original parties, which is Mr. Dodson and Mr. Cottrell, who got together to try and pursue this project, but also when they sought funding from a third party by Mr. Catania, that Mr. Catania brought in Mr. Shield as a financial funder to purchase the machines, but rather than have a normal transaction, which would be that the purchase of a loan made to the company in order to purchase the machines and security over the machines, it was turned slightly different by Mr. Catania and Mr. Shield, which is that Mr. Shield, through his company SES, purchased the machines and gave back an option. But further to that, Mr. Shield and Mr. Catania became shareholders in the company also. Hence, we've got the shareholders agreement, which includes not only Mr. Shield, but SES, the company, as well as parties. So there was to be a benefit to Mr. Shield, or through his company SES, if the option agreement had been exercised, whereby he would double the company would double its money, and there was a benefit also, in addition, to any profits that the company would make in due course. If I can take you to page 133 of the core bundle, which is the table that is within the petition.
133.
Yes, please.
You say core bundle.
Core bundle.
Yes.
It's a petition, and you'll see there the table of shareholders. Now, nothing turns on whether they're A, B, C, or D shareholders, but what has been attempted to do is to put the petitioners as B shareholders, you'll see, and there you have Mr. John William Rock as well, and hence there was no relief sought against Mr. Rock because he was effectively in Mr. Dodson's party. A shareholders were Mr. Cottrell, his son, and Neil Collins. C shareholder was Mr. Colburn, and the D shareholders were the financiers, who were Mr. Shield and Mr. Catania. Now, we know that Mr. Dodson has a background in engineering, and a company that he was a shareholder and director of was Key Technical Solutions Limited. We also know that Mr. David Cottrell has a background in engineering and was at all material times the owner effectively of DNA Technologies UK Limited. And we also know, and this is all in the judgment, that around 2011, Mr. Cottrell became aware of the possibility that the lines 1 to 3 at Hams Hall in Birmingham would become available for sale. Now, I will take you to these documents in due course, but just as a general summary, Mr. Cottrell's approach to BMW was rebuffed.
Yeah.
Later, Mr. Cottrell approached Mr. Dodson with a view to the two parties or their companies working together to try and achieve the purchase of these lines and subsequent turnkey project and sell the same to what we know now is that the Chinese market was very buoyant in relation to buying such projects. And the machines that were sold when Mr. Cottrell approached BMW, having been rebuffed, he was told that BMW were to sell the machinery as scrap, and that their normal outlet for getting rid of old machinery sold as scrap was to sell them to Stuckenberger. Stuckenberger, in turn, and I'll take you to the documents in due course, sold the same lines to Pegas on a as-is basis. There was no intention of BMW at any stage, and this was clear during the course of the case, of selling the intellectual property rights.
Sorry, say that again, I didn't hear
There's
you.
no intention of BMW selling at that time, selling the intellectual property rights in the NG4 engine.
Yeah.
We know that the lines consisted of 6 elements to it. And that's paragraph 9 of the petition. Now, the crankshaft, cylinder head, and cylinder block were substantial lines. For example, the Master Archive library in relation to those 3 was something in the region of 2,000 volumes of documents. The Conrad and camshaft were smaller lines. And line 6 is when you put all the parts that were made in lines 1 to 5 together to produce the ultimate engine. We also know there's no dispute between the parties here that initially line 1 was available, and subsequently line 2 became available, and line 3. As far as line 4 to 6 were concerned, they were situated broad, and there was a question of waiting for BMW to decide if and when they scrap those lines, hence the delays in the project. It was August 2012 that Mr. Cottrell and Mr. Dodson contacted Mr. Catania. Also in August 2012, Mr. Christopher Shield was introduced, director and shareholder of Shield Engineering System Limited, and he agreed to purchase line 1. Now, as far as the cost of the lines are concerned, they were sold as scrap. So, for example, line 1 was sold eventually by Pegas. So BMW sold it to Stuckenberger, Stuckenberger to Pegas, and Pegas to SES. Presumably all made a profit on it, but when it was sold to SES, it was about 790,000 euros.
Yeah. Although Stuckenberger was a scrap merchant, Pegas was a machine dealer.
Yes. And you've seen the documents also that Pegas obtained documents from Stuckenberger to say that Pegas was entitled to resell the machinery as well. Lord, there were two elements to the project. One was to acquire the lines and sell them on. The alternative, the additional part of which the company, that's where its expertise was, because anybody could buy and sell something, is the ability on the part of Mr. Dodson and Mr. Cottrell and their respective companies to actually install the line so as to produce an engine. The learned judge has already, and you've been taken to this, in his judgment, referred to the respective expertise of all the parties as far as the project was concerned. And these are all factors, in addition to the contractual documents that were entered into subsequently, which is why the learned judge eventually found that there was a quasi-partnership. Now, you've been taken to the revised Articles of Association. Now, there is a restriction, as you've seen, and I don't think we need to go back to that clause to remind ourselves, on how you transfer the shares.
Article 17.
Article 17.
Yeah.
Now, as a summary, I made a note of this a few days ago, which the process is as follows. If you're one of the shareholders, you want to sell your shares, you give notice to the company. The company then gets a fair valuation done, and that is without discount, and offers it subsequently to the existing shareholders. If no members want to buy the shares that are for sale, the last resort is to allow the shareholder to sell to a third party, subject to board approval, and more importantly, without any discount at all, i.e. fair value. And there is a corresponding clause, you see 10.1 in the shareholders agreement about the way that you transfer shares. Now, the shareholders agreement itself made every shareholder a party to that agreement, but in addition, specifically made the company SES a party also. And I shall come back to those documents in due course also. Now, my lord, my lady, have also seen the facility agreement between the company whereby SES was to finance the company in order to carry out the project to the tune of £1.5 million, which was put forward by SES. SES was given a debenture over the assets of the company. And finally, we know at tab 15 of the supplemental bundle, there was an option agreement, the option expiring on the 2nd of January 2014. Lord Justice Lewison has already taken the point that if one looks at the business of the company as defined in the shareholders agreement, that the business of the company shall be the design, sale, implementation of the turnkey automotive engineering projects on an international basis. Then that it says in open brackets business. The first project will be the acquisition of the lines. And 2.3, each party, which includes SES, as well as the shareholders, shall use its reasonable endeavours to promote and develop the business to the best advantage of the company. Each shareholder is to be a director of the company. And then we have the restrictions at clause 7.1. Now, the only exception to 7.1 is what is expressly stated in 7.2, which is to allow Key and DNA, which are Mr. Cottrell and Mr. Dodson's companies, to carry out work in reality, what happened was that the work that was being carried out was being done by these two companies, by Mr. Dodson and Mr. Cottrell, and then invoicing the company as contractors, and then they would be paid out of the £1.5 million that SES had provided. Importantly, the last few lines of 7.1 restrictions included any development in the business after the date of this agreement. Now, there is at 7.2 of the exceptions, and 7.3 are the best endeavours to promote the business of the company, which includes Shield as well. And I'll come back to how that reasonable endeavour. Sorry, I'll come back to how I say that applies to SES as well. The appellant's argument is that it doesn't. It would be pretty surprising if an express provision inserted into a contract to actually bring SES as being a party to this clause is 7.1, should then not apply to SES, and where SES was not accepted from the clause and the restriction in 7.1 as DNA and Key were in 7.2. And then paragraph 22, the good faith provisions. And 22.3, each party shall do all things necessary and desirable to give effect to the spirit and intention of this agreement. Now, my lord, taking all of those factors into account and the way that the project progressed, and having had the advantage of hearing the evidence from the parties and going through all the documents in the trial bundle, which was substantial, the learned judge was entitled to come to the conclusion that although the normal way would be to look to see what the contractual arrangements of the company were, and if there were other equitable restraints in addition to the contractual arrangements, to come to the conclusion that a quasi-partnership existed. But in my respectful submission, if the contractual arrangements between the parties contain similar restrictions that you'd find in a partnership, which we do have here, the court, and I'll take my lords, my lady, to the cases that I want to refer to in due course, it is equally possible for a judge, having heard all the evidence, consider the documents in the trial bundle, to come to the conclusion, looking overall, that in this context, a quasi-partnership had been established.
Well, now you say, looking at all the evidence and having heard all the evidence and looked through all the documents in the trial bundle, if the judge is considering the question, did the shareholders' agreement and associated documentation create a quasi-partnership, do you say that what happened after the execution of those documents is relevant to that question, as opposed to if there wasn't a quasi-partnership at the inception of all this, did it subsequently become one for some reason or another?
It's possible. Both of those possibilities are capable of coming to fruition.
I just want to know what reliance you place on the fact that the judge heard the evidence. So what evidence about what had happened after the agreements, or what happened before the agreements, or the whole lot?
The whole lot, in my respect.
Because it's not just a potpourri that you stir around and...
No, I accept that. My lord, he was perfectly entitled, as he puts it in his judgment, to rely on the 5 contractual documents.
That I understand. They're all associated documents, all entered into at about the same time, and that's fine. No problem with that.
In addition to which, he goes through the factual background in some length in the first 60, 70 paragraphs of his judgment, which also lead to the way that the parties operated, and this is why I went back to the respective roles in the company, what they're going to do.
Yeah, well, I understand that background as well, yes.
But it's only on that basis, I say, that he was perfectly entitled on what he heard and what he saw in the contractual documents in particular to come to the conclusion that he did. And the we'll go to the cases in due course, that the fact that there was an express clause, for example, in the shareholders agreement saying that this is not a partnership is not a bar. And the fact that there was an entire agreement clause is not a bar. It's only if you come to the conclusion as a court that there's no reasonable possibility of him coming to that conclusion in the context of this case, that perhaps that finding ought to be altered. But in my respectful submission, there was plenty of evidence before to come to that conclusion.
So you say this is a finding of fact by the judge, not his conclusion as a matter of interpretation of the documents.
I say it's a combination of both. The documents.
Because I think he says, doesn't he, that he's got to look to the documents alone.
He does say that, but he sets out the background as well before he gets there as to why all the parties had respective roles, why the shareholders agreement was entered into, how the project came about. And originally there was no company, it was just a project that was being proposed by Cockrell and Dodson.
Yeah. So he says, because he says, doesn't he, at 157, that he agrees that the court must interpret solely the 5 documents.
He does. I'm not going to try and shy away from that. He does say that. But my submission perhaps goes as high as this only, which is that having heard the evidence and then read these specific these provisions in these specific documents, then it must have had some kind of impact on him coming to the conclusion that there was a quasi-partnership. Lord, I don't know whether the court seeks to rise at 4:15 or 4:30.
We normally rise at 4:15.
Would this be an appropriate moment?
Yeah, all right, thank you very much. Well, obviously we have to finish this tomorrow, so we will. 10:30 tomorrow.
Anything on in court before us tomorrow morning?
Oh yeah, well, you guys can, obviously you guys can do whatever you like. As long as there's, Richard's just checking whether there's anything on Birss, in which case we.
Yeah. Yes, we'll save the back.
Okay, thanks.
There is also the fact that you're not coming tomorrow as well.
Is there something before us? Sorry, is there something before us?
Yeah, I know you jumped
He's
on
just
the
checking.
So.
You can vary it back to us and then
John's
put it off to your.
Yeah, well,
That's not going to get you in trouble at all.
Okay.
So yeah.
Duck out.
Yes. I went away to university and then came back and I did my pupillage because I did a lot of insolvency as a junior at which is now South Scotland.
Oh yeah.
And so Gabriel Moss and David Marks were my pupils. And at the end of
Is it a bit like Harry
I honestly, it's difficult to leave London.
This was in good shape when I originally bought it.
So going back to that and everybody said, well, there's no insolvency act here.
Yeah.
And now in Chambers we've got about 30 juniors who do nothing but.
It's a code.
Yeah, sure. Yeah.
Yeah, the difference in the detailing is all different. Yeah.
See, I've never paid attention.
You didn't read it, you just thought, oh, that one, I just thought.
We will finish tomorrow. There's a lot of it. I don't need to go to the document.
Well, you may.
Yes. No, hopefully. Well, I load all the cost, yeah. They have so informed you. Yeah, sorry, I looked at the
I'm always optimistic that we can finish shorter than that.
If anything, it always tends to go the other way, doesn't it? Tribunal.
Yeah.
Very pleasant. Regulation.
Birss used to be our presiding judge.
Oh, did he? Right, yeah. So you know him, do you?
I did about 2 or 3 things in front of him. Do you know if anything's listed?
So this is the first, I think you can leave your stuff here if you want to, there won't be any quote before 10:30.
Perfect, thank you.
Just ensure I'm in position. Yes,
My
thank you.
clerks are going to come and take the box.
Just see if we've got somebody outside.
Yes, you have.
So we won't be seeing you tomorrow.
Yes, yeah, I'll be watching you on the last 2 hours.
Good TV. Well, good to see you today.
Yeah, you too.
Thanks for bringing that big file that never.
So I'm just going to ship everything back.
No, I'm actually taking one of my better referrers out tonight.
Your watties?
One of my better referrers, he's an Italian IFA who lived down here. Actually, Richard did some work for me for in the past as well.
Yeah. Yeah, successfully, wasn't it? There's no one. She said there was no one in before us, didn't she?
She did.
Was there anyone else outside? Saw.
Streams off.
Yeah, so Alex and Cindy going back tonight.
Oh,
I'm staying down in London, so I'm taking one of my referrers out.
referrers being someone who refers work your way.
Indeed, yes, yes. Yes, indeed. So, yeah, exchange from lunch between other different bits and pieces. But,
Get it outside.
good for
I must
business,
be aware.
I haven't taken him out a while, so yes.
What sort of stuff do you get? Just selling your stuff?
Get some of that. I mean, the last one we had from him was a dispute between 2 parties. We weren't sure and fallen out, so it was a straight partnership solution.
Oh.
So with some interesting characters. Sometimes with that. There's shareholder thing to fall out, contract stuff. So yeah, a bit of a mixed bag. You just don't quite know. It's always a bit hit and miss. You can get nothing that's worthwhile for years. And then get 5 or 6 brilliant, completely different random disputes. But it's
The kind of guy you need to keep sleeping.
he's the sort of person that just
No, none of this stuff, unless you can find a place for that, because otherwise that's going to get nasty tomorrow. I'll do it.
Okay.
Yeah, so that can stay then.
I can stay here as well.
Yeah.
Okay. Thanks, mate. Yeah.
Thanks. See you about that.
Everyone's going to come in, but I'll put them in the box just in case.
Good job to see you guys have got a few files with you. Not stocked. I don't know.
Oh, we. You just came with the one and then everything else.
No, it's
on the
not.
laptop.
I'm really sure what's in any of them. I don't sure I want to find out either.
I think there's lots of copies of your authorities.
There we go, further copies. Oh, I didn't apologise, did I? But
I'm not gonna take those. I'll leave those.
I can do it for now. Yeah, I'll put a pin.
Just tell me.
Yeah, we're all good.
No.
We're all good.
Richard, give the pin.
What you were doing with it.
Right.
All good.
We're all sorted. Yes, good.
Thanks for your help today.
Thank you so much.
Thank you.
Bye-bye.
Actually, can I